to move on to Direction 110. Just for clarity, for factual purposes, it's my understanding that the text of Direction 1110, as it relates to the strength and nature and duration of the ties to Australia, uses the exact same language as was under place in Direction 90. Is that correct?
Senator, let me get the experts who've done the drafting to the table.
Senator, it might be more accurate to say it's a hybrid of the in MD 99, the ties and connections to the community became a primary consideration.
That's a separate question. I'm coming to that.
Okay.
I'm just the text of it is what I'm interested in for the moment.
So yes, it's the text. Once you get like where it,
yes.
Yes.
So we've reverted to the strength, nature, and durations of ties in its drafting terminology back to Direction 90.
Yeah. Yes.
The only thing that differs from Direction 90 in respect to the wording is that under Direction 110 it's a primary consideration, and under Direction 90 it was a secondary consideration.
That's correct, other than once you take into account the way the new Section 7.2 to 7.2 works, in that it's changed the way primary considerations are weighted against each other. But yes, it is now it is a primary consideration with the text from mirroring what was in MD 90, but noting now that safety of or protection and safety of the Australian community is to be weighted higher generally than the other primary considerations.
It seems maybe there's a very good legal reason for this, but it seems strange to me to have primary considerations that are not equal. Why is one primary? They're all called primary considerations. Why is one more equal than the others?
I think that's ultimately a question for the Minister of the day who's issuing the direction and how they want to direct the considerations are weighted.
Because if you wanted to make sure that strength, duration and ties to Australia was not given too much consideration, you could make it a secondary consideration as it was previously, if that was the objective of the policy.
Well, I think what the way it's been done by this Minister is to say safety of the community is number one, and then there are four other primary considerations that are weighted. So he hasn't chosen to place ties to the Australian community as an other consideration. He's chosen to place it in that sort of group of four that sit underneath safety of the Australian community. But ultimately, it is a question for the Minister about how he wants decision makers to manage that weighing. Noting he can't fetter them in
Understood. Yeah. I mean, it seems like it's all primary considerations are equal, but some are more equal than others. Why wasn't the protection of the Australian community elevated to be, say, a paramount consideration? You could have had paramount considerations, primary considerations, and secondary considerations. That's done in other areas of legislation.
Look, as a matter of administrative law, it's not possible to direct in such a way that fetters the discretion of the decision-making. So the way paragraph 7.2 has been drafted is intended to recognise or balance the Minister's concern that he would like safety of the Australian community to be generally given more weight, but the word generally is very important to ensure that we're not fettering.
Generally doesn't fill me with confidence that we won't have more decisions like we've seen previously, particularly given it's a primary consideration to consider their ties to the community. So is it your evidence that you could not have had a paramount consideration of protection of the community?
Senator, I'm just being cautious because I don't want to provide you with I'm not here to provide legal advice.
No, but
to
it was
the
my
committee.
understanding of your previous answer that you implied that it would have fettered the decision maker. Is that what you were saying? To have a paramount consideration of community safety?
The drafting that's reflected here is the drafting that reflects our best view on what and how far a ministerial direction can go in fettering a decision maker.
Yeah, but that doesn't still directly answer my question. Why couldn't it have had a paramount consideration of community safety?
The concern would be that we would be fettering decision makers by directing a particular outcome.
Okay. So why then couldn't we just return to the handling of Direction 90 and make ties to the Australian community a secondary consideration?
I think that's a matter of policy and the content and the way the minister wanted to put the direction
Indeed.
together.
So it's ultimately the minister's responsibility that this has been retained as a primary consideration, and therefore the risk that the AAT makes decisions in the way that they did under Direction 99.
So Senator, I think it's a statement of fact that the ministerial direction is the policy of the minister. But as Ms Sharp has been explaining, the drafting and the weighting given to community safety was a very deliberate decision.
Okay. Question for the minister. Given that the government has now replaced Direction 99 with Direction 110, does the government accept responsibility for the implications of Direction 99 in releasing people into the community who otherwise wouldn't have been?
Well, I mean, it's a matter of record, Senator Patterson, that the AAT overturned exactly the same proportion of cancellation decisions under Minister Dutton, then Minister Dutton, as they did under ministers in this government. So my question is, my statement would be that I've never seen Mr Dutton take any responsibility for any of that that occurred when he was the minister.
So, Minister, if there was nothing wrong with Direction 99, why has it been updated?
Well, I'm sure that there were adjustments made to ministerial directions over the various years that your government was in power as well.
That's not the question, Minister.
But you're trying to
why
create...
Why is the government...
No, throughout this debate, over the last few months, you have attempted to hold the government to a different standard to the standard that you were prepared to apply to Mr Dutton and your government. And just as under this government, around 50% of AAT decisions overturned visa cancellations, exactly the same thing happened under Mr Dutton. So it seems that you're only ever interested in one side of politics taking responsibility.
You're the government. You're the minister representing
Or did Mr Dutton
the
ever take
portfolio.
responsibility?
It's not your role to ask questions to me.
Senator Patterson, I've stretched your time a little.
Okay, just a final question.
Yeah,
Good,
and we
Chair.
will come back to you before we conclude tonight.
Sure,
so.
just a final question on this matter then,
Of
Chair.
course.
Thank you.
Yeah.
So, Minister, is it your evidence that there was nothing wrong with Direction 99 and it didn't need to be replaced by Direction 110?
Clearly, by altering the direction, the government felt it was necessary to make much more clear to the AAT what the government's expectations were and the community's expectations were, and that's what we've done.
Okay,
Thank
you,
you,
Chair.
Minister. Thank you, Senator. Senator Ghosh.